All rise, veuillez vous lever. The International Residual Mechanism for Criminal Tribunals is now in session. L'audience du mécanisme international appelé à exercer les fonctions résiduelles du tribunal pénal est ouverte. Please be seated.
Well, good morning, everyone. The trial chamber will now hold the pre-trial conference for this case pursuant to Rule 81 of the rules, and that will be followed by a status conference under Rule 69. First of all, who appears for the prosecution?
Good morning, Your Honours. The prosecution today is represented by myself, Rupert Elderkin, Thomas Logel, Rashid Rashid, and Maria Yakusheva.
Thank you, Mr. Elderkin. And who appears for the defence?
Good morning, Your Honours. The defense team today is made up by myself, Emmanuel Altit. We have Mr. Jacobs with us, and I would like to introduce to you Mrs. Gassena. She is our linguistic assistant.
Maître Altit. Can the registry now confirm to me that Mr. Kabuga, who is in court, is receiving the translation of these proceedings in the Kinyarwanda language?
Your Honor, this has been tested a moment ago, and I can confirm that he can hear loud and clear in Kinyarwanda language. Thank you.
Thank you very much. Before going into matters that are determined at this pre-trial conference, I'll first of all cover some recent procedural developments in the case to bring everyone up to date. The last status conference was held on the 11th of May. The trial chamber thereafter held hearings on the matter of Mr. Kabuga's fitness to stand trial on the 31st of May and the 1st and 7th of June. On the 13th of June, the trial chamber decided that Mr. Kabuga had not demonstrated that he was unfit to stand trial and directed the proceedings in the case to commence at the Hague branch until further order. Mr. Kabuga appealed the decision, and the appeals chamber affirmed the trial chamber decision last Friday. Since the hearings related to Mr. Kabuga's fitness to stand trial, the trial chamber has issued 6 decisions on prosecution motions to admit evidence under Rules 110, 111, and 112, bringing the total to 8 decisions in relation to about 70 witnesses. 4 motions filed pursuant to Rules 111 and 112 that concern 23 witnesses are under consideration. And my understanding is that that will conclude the presentation of motions under these rules. Now, Mr. Elderkin, can you confirm that?
Your Honour, barring one motion under Rule 110 concerning two witnesses who are coded CAB 115 and 116, and a slight chance of one relating to the witness CAB, I think, 108. That's correct. Apart from that witness, who indeed we are more likely than not to lead his evidence, that does conclude it. And the explanation in relation to 115 and 116 is that they are witnesses added after the initial filing of the witness list, and they are chain of custody witnesses essentially for RTLM radio broadcast materials. There's simply a lot of translation work that has been ongoing for them. But in terms of any witnesses who will appear before the chamber, everything has been submitted, bar 108.
All right. Well, thank you for that clarification. The important point is that clearly a great deal of effort has been made to submit this material at the earliest possible opportunity, and for that the chamber is grateful. In my role as pre-trial judge, I met both prosecution and defense counsel in the course of this week, and various discussions took place with a view to ensuring that everything is properly prepared for the trial. I now turn to matters at the heart of this pre-trial conference. First of all, the scope of the case. The prosecution have filed a revised 70E2 witness list, which indicates that 14 witnesses originally included will not be required, and which estimates that the time necessary for the prosecution part of presenting their case will be about 40 hours. That's for direct examination by the prosecution. The prosecution has also indicated that it is not pursuing indictment paragraphs 45(8) through to 45E and 61A. That was originally indicated at an earlier status conference in February. Now, with that introduction, can I ask you, Mr. Elderkin, if there are any other comments you wish to make on the scope of your case?
Your Honour, no further comments.
Thank you. And Maître Altit, do you have any comments to make at this stage on the scope of the prosecution case?
Pas de commentaire.
No, thank you, Your Honour. No comments.
I should make it clear that these are matters which were discussed with, by me, with counsel, with both counsel present throughout the discussion. Well, in light of these comments so far, The trial chamber notes that indictments paragraphs 45A to E and 61A are dropped. There's no need, in the opinion of the trial chamber, to order the prosecution to shorten the time required for examination in chief of any of its witnesses pursuant to Rule 81B, and also considers that no orders pursuant to Rules 81D or E are necessary. The Chamber, pursuant to Rule 81C, adopts a number of witnesses and the time available to the prosecution to present its case as reflected in the revised Rule 70E2 witness list filed yesterday. I now turn to the way in which it is proposed that some of the evidence is presented. The prosecution has expressed a preference to have several of its witnesses testify by VTC, that's by video, from Arusha and Kigali. Generally, and in view of the particular circumstances of this case, the trial chamber is amenable to hearing witnesses via VTC from both these locations in order to facilitate the smooth and fair conduct of trial. The trial chamber is mindful of the defense's initial reticence on this point and reluctance to commit to accepting that this is appropriate for the number of witnesses proposed. Nevertheless, the chamber encourages the defense to engage with the prosecution. Further, I know that engagement has already occurred, but to engage further with a view to reaching agreement on this. If agreement is reached, the party should then file a notification that identifies the witness or witnesses for which no opposition to appearance by VTC applies. If agreement cannot be achieved, however, the prosecution should apply to the trial chamber for decisions in relation to the witnesses in respect of whom they seek to adopt that procedure. I now turn to what is generally referred to in this institution as the modalities. That's the specific arrangements for the trial. We all know what the normal arrangements are, but it's plain in this case that special arrangements are necessary. On a number of occasions, Mr. Kabuga has appeared by VTC himself from a facility at the detention unit. And that will continue to be acceptable so far as the chamber is concerned. But he should note particularly that should he choose to be in court, then that presents no difficulty for the institution. The special arrangements necessary for your presence, Mr. Kabuga, in this courtroom will be made. Whatever is required will be done. In the past, there has been a measure of uncertainty up to the last minute about whether you would come to the courtroom or instead participate via the VTC communication at the detention unit. It causes difficulty if this is not established, the choice is not made a reasonable time before the proceedings are due to commence. So I asked the defense and the registry to find a workable solution that will allow effective communication to the chamber and any other necessary party if there is likely to be a change in the arrangements made for any given day's proceedings. The earlier the arrangement can be relayed to the chamber, the better. And it's particularly important because in this case, because a routine is an important part of Mr. Kabuga's life, and the chamber is intent upon ensuring that matters are dealt with in a regular, routine fashion so far as possible here. To modify any difficulties that he is likely to experience otherwise. So the starting point will always be that Mr. Kabuga will be expected in court. Should that not be the case, then hopefully in the next few days, defense and registry will have established a protocol to ensure that adequate notice is conveyed to the chamber and to any other party who requires to know. It must be plain to anyone observing this case that the chamber will be able to sit for only a limited period of time each week. Although the defense initially indicated that 2 days a week were appropriate for a period of 2 hours on each occasion, the medical advice that's been given to the chamber is that it would be acceptable for there to be 3 sittings of 2 hours per day in each week. And at the meeting I had with counsel, it was accepted in principle that that recommendation was not unreasonable. So the sitting schedule that the chamber has in mind is 3 days a week for 2 hours. And these 2 hours would routinely be between 10 and 12. In his initial guidance to the chamber, the medical officer of the detention unit assumed or noted that Monday, Wednesday, and Friday would fit into such a pattern. The chamber invited him to reflect on whether it was vital that these 3 were the days in every week. For him and those with whom he consulted, the important thing is that there is regularity in the routine. And that, in fact, can be achieved equally well and perhaps possibly in better, is even better if the days were to be Tuesday, Wednesday, and Thursday. Now, the Chamber does not envisage changing from one combination to another on a regular basis. The Chamber envisages settling on one, starting the trial, observing how that works out, and only if necessary changing that regime. Now, that's something that's developed since we had our meeting earlier in the week. So first of all, can I have comments from the prosecution about that possibility?
Your Honour, either of those patterns would be entirely acceptable and workable for the prosecution, and in relation to witnesses at any of our proposed locations, we would defer to the best needs and interests of the accused and of the defence, and of course to the bench.
Thank you, Mr. Elderkin. Maître Altit.
Merci, Monsieur le Président.
Thank you very much, Your Honor. I believe that what is certainly important here is the well-being of Mr. Kabuga and flexibility. Those are the two essential words. And we are fully in agreement with the advice by the doctor, which are absolutely reasonable. And under the reserve, as you said, Your Honor, if new conditions should arise, we will, of course, adapt to these new conditions.
Well, in light of these factors and comments, the Chamber's position is that the scheduling for the case will be on the basis of 2 hours per day between 10 and 12, 3 days a week, Tuesday, Wednesday, and Thursday. If at any point, for any reason, Mr. Kabuga were to waive his right to participate, then the Chamber would be probably able to sit one additional day. I don't see it being any more than that. And that would only be in the exceptional circumstances of his waiving his right to be there for whatever reason. I'll come shortly to the specific dates on which this arrangement will commence. The next matter for me to deal with is a fairly bureaucratic matter, and that relates to filing. This case is an Arusha case being conducted at the Hague branch, which means that there are staff working on this case in both branches. That causes certain difficulties in relation to the formalities of filing when the time difference between the 2 locations extends to 2 hours a day. So the Chamber intends to regard as timely any filing submitted by 11:59 p.m. Hague time on any given date. That's the latest point at which a filing might be made. I now turn to the initial opening trial schedule. At the meeting I had with the parties, there was discussion of allocating 29th and 30th September for opening statements. Now, I appreciate that that's a Thursday and Friday, but bearing in mind the nature of the procedure involved and the circumstances affecting the various personnel involved, these do seem to be the most appropriate dates on which to hear opening statements in this case. Following on that, the trial chamber would propose the evidence start on Wednesday, the 5th of October, continue on the 6th, and then in subsequent weeks continue on the Tuesday, Wednesday, and Thursday. There will be appropriate breaks as and when the case reaches stages where we are all agreed or the chamber decides it's appropriate that there should be some interruption. So that is the schedule we have in mind. Before making any final decision, however, again, I invite you, first of all, Mr. Elderkin, to indicate if there's any comment you wish to make.
None, Your Honour. And if it would assist, we would envisage, barring any technical calamity, to complete our opening statement in 2 hours or less, so on the Thursday.
Thank you. Now, Maître Altit.
Oui, Monsieur le Président.
Mr. Altit, yes, Mr. President, Your Honor, we have no specific comment, and we were going to propose the same thing as the prosecutor regarding the opening statement.
An opening statement.
Oui, oui, Monsieur le.
Mr. Altit, yes, Your Honor. It will be an opening statement. That would be quite a quick statement. And if I may, maybe we could deal with this point right now. I would like to keep part of the opening statement for the beginning of the presentation of the defense case.
Thank you. Mr. Elderkin, I think there may not be a rule that makes provision for what Mr. Maître Altit has proposed, but the Chamber is inclined to accept the proposal. What's your view?
Your Honour, entirely acceptable to the prosecution.
Thank you. Well, very well, Maître Altit. You may divide your opening statement and make initially a statement at the start of the trial and another at the opening of the defence case.
Merci, Monsieur le Président.
Mr. Altit, thank you, Your Honour.
The Chamber orders the trial to commence at the Hague branch with opening statement scheduled for 29th and 30th September and for the evidence to commence on the 5th of October. There is one significant outstanding matter before the Chamber. The Chamber seized of a request for a change in Mr. Kabuga's representation. That matter is under consideration and a decision will be issued as soon as the Chamber has had an opportunity to consider the matter fully. Now that concludes what requires to be dealt with in the context of the pre-trial conference. As I indicated at the outset, this session doubles all as a pre-trial conference and status conference, and I turn to the latter, the status conference, and I direct my attention first of all to Mr. Kabuga himself. Mr. Kabuga. Is there any matter you wish to raise with the Chamber?
Yes, I have a question.
Please state it.
I wanted to change counsel. I would like to change Mr. Emmanuel Altit, and I would like to have La Rochelle to support me as a counsel.
Chamber, as I have just indicated, the Chamber has before it an application submitted on your behalf to change representation, and that will be dealt with and a decision issued as soon as possible, probably in the next few days. Is there any other matter you wish to raise with me?
No. I have no other issue I would like to raise with you.
Maître Altit, is there anything you wish to raise?
Non, Monsieur le Président, merci.
No, Your Honor, thank you.
Republican?
Your Honour, only in relation to the question that you asked in relation to witness cab 005 at the informal meeting on Tuesday. That's a witness for whom we have made an application for his evidence to be admitted pursuant to Rule 111, and a number of the associated exhibits indicated in that motion are pending translation. I can provide my comments on that either in writing or now orally, as you would prefer.
I think we would prefer to have them now.
So, Your Honour, this is a witness who is being called largely to authenticate the RTLM radio broadcasts, a collection of 59 tapes. And while the 59 tapes are associated and listed, therefore, as associated to his evidence, the understanding of the content of those materials does not support or isn't necessary for the understanding of his statement, but rather his evidence provides the authentication of the tapes. The translations will not be ready in time for his evidence. They're currently undergoing translation. Given the volume, it will take time, and we will only be able to deliver them sequentially as and when we receive them. We would propose that his evidence can be heard because he is not a witness who is being called to discuss the content of the tapes, but simply explain how they were provided to the ICTR OTP, and then leave those as marked for identification pending the receipt of the appropriate translations.
Remind me of the way in which his evidence is intended to be presented.
So the proposal is that we have a statement, a Rule 111 statement. He's the witness for whom we've asked for 2 hours in total for direct examination, and that combined with the admission of the statement. The statement is highlighted on our on our list of his evidence as pending translation. That's translation of the English version, but the Chamber has already received his statement in French, which I understand is a working language and usable for consideration of the application.
Can you give me an indication of what might be covered in the 2 hours that you think is necessary when he doesn't say anything material about the content?
There are a number of other items also proposed as associated exhibits. For example, documentation related to the RTLM radio station as an organisation, and because his role was in media monitoring during the relevant period of events in this case, he also does have direct evidence, but relating to his own observations during the pre-genocide and genocide period, unrelated to the content of those 59 tapes.
Now, it strikes me that the content of these tapes is fairly significant in the overall context of this case.
Absolutely.
So when do you envisage the Chamber being able to consider the terms of the tapes, transcripts?
So translation work is underway,
Yes.
and in most cases, because these are tapes that cover whatever was recorded at the time the person making the recording hit the button on the machine, we've selected the excerpts of relevant material, which has speeded up the process. We'll be delivering the translations into eCourt as soon as each one is made, rather than bunching them up. The entire set, I'm advised, will not be completed, most conservatively, until probably December. But again, given the pace, the modalities just proposed, there will be further witnesses who will be testifying either to tapes that will have already been provided in translation, or be testifying, giving freestanding evidence about their own experience of the broadcast without referring to the tapes per se.
Are there not available to you in any event a number of translations from previous cases?
Your Honour, indeed, and I'm talking only here about a subset of the broadcasts for which translations are unavailable. I can tot them up now, but it's more than half of them already do have existing translations, indeed, from previous cases, and so those can be worked with. This is, in fact, the whole set was admitted in the Nahimana et al. Proceeding, and translations weren't provided, but they were admitted as a collection, and then excerpts were chosen. that haven't hit all of the broadcasts. We're seeking to be more comprehensive and therefore providing excerpts across the board. But the majority of the material, yes, is already available for the parts that we consider relevant from more than half of the tapes. And I say more will be provided as and when the translations have been completed.
Now, witnesses relating to the RTLM part of the case are to be led at an early stage.
The first batch of witnesses, yes, indeed. Of those witnesses, I think more than half of them relate to very specific incidents and are not giving evidence that has crossover relevance to the outstanding tapes. They're talking about their own experience of hearing the broadcasts at the time of the events. So we wouldn't be intending to actually use the materials. And on my reading of the order on the guidelines for trial proceedings, if we will not be using the materials, then we're on safe ground. We can go ahead and hear those witnesses, and we wouldn't be trying to play tapes for which there is no translation available.
But these witnesses might be heard over the period of about 3 weeks, say. So quite speedily you'll be able to present an amount of that. Is MICT-13 not going to be put in a difficult position so far as his challenge of these witnesses is concerned?
I believe not, because we have not made any attempt to associate. Well, part of the answer is that the materials available to defence the whole set is in Kinyarwanda, which is a language that is the language of the accused, and I understand there are Kinyarwanda speaking and reading capabilities on the defence team, but we're not going to be seeking to dig out any parts of the set of materials that are only in Kinyarwanda for the bench's understanding as well as for our own.
No, I'm thinking of the situation where you're not in a position to refer to English or French translations at the stage a witness is giving evidence, and MICT-13 may have some issue that he might have difficulty with the cross-examination on.
I understand the hypothetical, but my knowledge of the material is such that I don't think we're at risk of that arising, because let's say the targeted translations that already exist from prior proceedings cover the evidence we will be leading at those stages.
All right. I'm doing my best to understand the distinction, but
it would be as if one had recorded BBC broadcast over a several-month period, and we haven't yet got translations of the whole of the output, but the material that we'll be leading doesn't relate to the untranslated portions. It relates to only the days on which we already know we have something we want to be discussed, and that is translated.
yeah. But there are two sides to this case, Mr. Elderkin. It's not just what the prosecution wants to present, and if material exists that is produced in the case, then the defence really ought to have the opportunity of satisfying themselves that there's nothing there that they ought to be concerned about, or that seeing whether there's something there that they might want to make use of. Now, you refer to the Kinyarwanda speaking capacity of the team, but that confines the availability of personnel to work on a massive amount of material.
I do understand that the material in Kinyarwanda is not just in audio format, but also has been transcribed into Kinyarwanda documentation, which I would be surprised if that is not word searchable, for example. So to some degree, I take your honour's point. I would expect that if those materials can be word searched, that it would reduce largely the required effort involved to find what the defence may wish to use amongst those materials.
Right, thank you, Mr. Elderkin. MICT-13.
Thank you, Your Honour. Your Honor, ladies and gentlemen, we're against the prosecution's proposal. We're against the proposal of the prosecution. The defense must receive in due time the documents that are useful for the preparation of the cross-examination. That's the first point. But there's also something else. When you prepare a case, what the witnesses say is very important because it responds to other things that are being said. And to understand the value of a statement, you also have to refer to other statements and witnesses, which means that, one, we need to have the translation in a language that would be French or English to prepare the cross-examination. And secondly, we also need that to prepare the other cross-examinations, because this makes a whole thing in this case. That's one thing, Your Honor. The second thing now is that the excerpts that have been translated by the prosecution would not be useful. Why? But because if we're not given the context, and in this case of a transcript, we need to have the transcript. We need to know what was said just before or just after. And we need to have an overall view of this thing, just to know the tone in which it was said, just to understand that. That's absolutely indispensable. And the excerpts which would be arbitrarily chosen by the prosecution would in no case be useful. On the contrary, they can only lead to misunderstandings. And for these two reasons, the defense is against the proposal of the prosecution. We do not agree with that. And I repeat, we need to have all the elements in due time to be able to do our job.
I don't think I have anything further to add beyond my submissions just now, Your Honour.
Do you not accept that the devil is in the detail, that the context can be all important in any comment that is made? In fact, it's what politicians live on.
I absolutely accept that, Your Honour, but our obligations under the rules for disclosure have been fully met. My view is that the defence have been entitled to and have received, I don't know the exact disclosure dates of these materials, but they are usable, searchable, and like any other category of disclosure, barring witnesses' prior statements, these fall into the same category as any other material. The specific order on the use of materials during this trial governs languages that must be provided. Working language versions of these materials must be provided, I think, at latest a month in advance of the proceedings in e-court. But as I have said earlier, we are not proposing to use these as exhibits to bring them up before the court with that first witness or with indeed any other of the witnesses in the first batch. So I believe we're fully compliant. And further to compliance, I understand the hypothetical disadvantage, but the entire disclosure regime foresees that the defence will be required to work with a collection of materials that will include often materials in Kinyarwanda, be they RTLM broadcasts, where just by the label we have a common understanding that they may be relevant to the substance of the case, but indeed other books, publications, newspapers, any material that may lie out there, the prosecution does not, and in terms of resources, should not rightly be expected to have to translate that full set of material in order to go further than the rules require.
Thank you. The chamber is going to adjourn briefly to consider this, and then we'll return to the bench to complete the pre-trial conference.
All rise, veuillez vous lever.